Good day, everyone. Welcome to our live online information session organized by the European Labour Authority, or short ELA, in cooperation with the Road Safety Authority, Department of Transport, and the Workplace Relations Commission of Ireland. Today's session focuses on the upcoming application of relevant provisions of Mobility Package 1 to light commercial vehicles, or short LCVs, used in international transport of goods or cabotage. These rules will come into effect on 1st of July 2026. Before we dive in, a quick technical note. Today's session will be held in English. However, a recording with interpretation in all official EU languages will be available on this YouTube channel in the coming weeks. If you would like to watch this in your language, please make sure to follow the ELA YouTube channel to be notified when these versions are uploaded. My name is Ivan Mekinda, and I work in the Information and Eures unit at ELA. We are an EU agency which contributes to ensuring fair and effective labour mobility across the EU, and we assist Member States and the European Commission in the coordination of social security systems in the EU. Road transport is a very important pillar of our work. And in the Information unit, we aim at facilitating access to information and services for mobile workers and their employers. So in road transport, our target groups are therefore drivers and operators. I will be your moderator for the next 3 hours. As you can see on the agenda slide, we have a comprehensive lineup covering short overview of the EU legislative framework for LCVs, the international EU transport of goods or cabotage, community licensing in Ireland, driving and rest time rules, posting of drivers, national enforcement perspective, and a practical presentation on ELA information activities in the road transport sector. For each topic, we will hear experts who will summarize the most relevant rules. Also, a quick reminder, these presentation slides will be available on the ELA website starting tomorrow, that is 29th of April, and you can find the link in the video description. I would say that it's time to hear from our opening speakers, and I would like to invite my colleague Monica Dinin, who is a National Liaison Officer from Ireland, as well as Justin Martin from the Road Safety Authority of Ireland, to share a few welcoming words. So Monica, please, the floor is yours.
Thanks, Ivan. Good morning, everyone, and a very warm welcome to this ELA live online information session. My name is Monica Deneen. I'm the National Liaison Officer for Ireland at the European Labour Authority. Pleased to open this event today. The event is organised by, as my colleague mentioned, by the European Labour Authority, together with our partners in Ireland, the Road Safety Authority, the Department of Transport, and the Workplace Relations Commission. Today's session forms part of the broader information and awareness raising campaign, which was launched by the ELA in November 2025. And the campaign is aimed at supporting the operators, drivers, and the authorities in preparing for the new EU rules in relation to light commercial vehicles. And the new rules will apply from the 1st of July this year. The campaign includes 3 information sessions. The first one was held in December 2025 last year, and it focused on the basics and the introduction of the new legislative framework. Today's session is the main session of the series. It builds on the initial session by providing updates covering additional and broader topics and responding directly to the questions that were raised during the December session. And as a result, the agenda for today has been specifically tailored to reflect these questions and any practical needs. A final summary session is planned to take place on 30th of June this year. I hope you find today's event useful, practical, and that it will help you to prepare for the changes ahead. And with that, it is my pleasure to pass the floor to my colleague, Justin Martin, Head of Enforcement at the Road Safety Authority in Ireland, for further opening remarks. Thank you and enjoy the event.
Thank you, Monica. Good morning, everyone. My name is Justin Martin. I'm the Head of Enforcement at the Irish Road Safety Authority, and I'm delighted to participate in today's event. For decades, the world of tachographs and strict driving time regulations was primarily the domain of heavy goods vehicles and buses. Light commercial vehicles, specifically vans between 2.5 and 3.5 tons, have largely outside this specific regulatory framework. However, as part of EU Mobility Package 1, that is changing fundamentally. Starting on the 1st of July, the rules regarding international transport are shifting. If you are operating LCVs for hire or reward in international trade or conducting cabotage, a second generation smart tachograph is no longer voluntary, it's mandatory. From that date, these vehicles must be fitted with smart tachograph version 2 or a G2 V2. This isn't just about recording hours, it is a major technological upgrade. These devices will automatically record border crossings using GNSS positioning, detect loading and unloading activities, and improve enforcement through dedicated short-range communication technology, which allows authorities to check data remotely while the vehicle is moving. The goal is to ensure a safer, more transparent, and fairer competitive landscape across Europe, reducing driver fatigue and ensuring fair wages. The shift requires significant planning. If you own or operate vehicles in scope of the new rules from the 1st of July 2026, we would advise that you retrofit your existing fleet with approved G2 V2 units before the July deadline. Ensure your drivers apply for a driver card if they don't already have one, and apply for a company card if you don't already have one. Apply for a driver attestation in respect of any non-EU citizens you employ. Organise training for your drivers, including using the mode switch and making manual entries. And download driver cards for your drivers at least every 28 days and vehicle units at least every 90 days to monitor their compliance with the driving and resting time rules, and retain these records for at least 1 year, extending longer if being used to record working time. So failure to comply after July 2026 may lead to heavy penalties, including significant fines and potential vehicle detention during roadside checks. While we are approximately 2 months out from the deadline, the message from the regulators is clear. Please do not wait. Many companies will need to retrofit their vehicles, and waiting until the last minute could lead to waiting times at workshops. The change is a significant step forward towards harmonising road freight safety. It is time for LCV operators to stop seeing themselves as outside the scope of digital tracking and start acting to ensure their compliance, safety and operational efficiency. And to assist with this, we have a great lineup of experts today who will speak on the EU legislative framework underpinning the changes, with a specific focus on operator and driver obligations in relation to community licensing, compliance with driving and rest time rules, and posting of drivers' rules, and also a session outlining what operators and their drivers can expect should they be subjected to a roadside enforcement check. I really hope you enjoy the event. Please take plenty of notes and don't be afraid to submit questions via Slido. I'll be back for some closing remarks at the end, but for now, I'll hand you back to our moderator for today. Back to you, Ivan.
Thank you, Monica, and thank you, Justin, for these kind welcoming words. I would say that now it's time to start with the presentation. And first up today, we have Luca Tassoni from the European Commission, who will deliver a presentation on EU legislative framework for LCVs used in international EU transport of goods or cabotage. So Luca, the floor is yours.
Thank you and good morning to everybody. About the new obligation for the LCVs, we have to make reference to the general rule, which is in Regulation 165, according to which the tachographs shall be installed and used in the vehicles to which Regulation 561 of 2006 applies. And so, as already said, by the mobility package, it was inserted in Article 2, Paragraph 1 of Regulation 561, this new provision on the obligation of the installation of the tachograph for the LCVs. This obligation from the 1st of July 2026 regards the newly registered vehicles, but also the vehicles that are already registered. And we are referring to the second version of the second generation of the tachograph, the so-called smart tachograph. It is important to remember that this obligation on the LCVs is related to the vehicles which are engaged in the transport of goods, and also in relation to international transport operations. For the definition of international carriage, we can make reference to Article 2nd and the second paragraph of Regulation 1072, in which a laden journey undertaken by a vehicle in which the point of departure and the point of arrival of which are in two different member states, or another hypothesis, from a member state to a third country or vice versa, or between third countries with transit through the territory of one or more member states, and also all the unladen journeys in conjunction with the carriage referred in the previous points. Another situation is the cabotage operations, and we can find the definition of cabotage operations in the sixth paragraph of Article 2 of Regulation 1072, which is the national carriage for hire or reward carried out on a temporary basis in a host member state. The obligation is in relation also to the maximum permissible mass, which exceeds the 2.5 tons. And this parameter is defined by the point M of Article 4 of Regulation 561 as the maximum permissible mass, the maximum authorized operating mass of a vehicle when fully laden. So it is indicated in the registration certificate of the vehicle. As regards the geographical scope of this new obligation, of course, and also the geographical scope of Regulation 561, in accordance to its Article 2, Paragraph 2, we have to make reference to the territory of the European Union, but also to the territories of Switzerland and all the countries which are party to the agreement of the European Economic Area, Iceland, Liechtenstein, and Norway. And the obligation of the installation of the tachograph in the LCVs is also in the TCA, because Article 3 of Annex 31, Part B, Section 2, set out that from 1st of July 2026, the vehicles, the LCVs, when operating on the territory of another party, should be fitted with the smart tachograph. So the geographical scope of this obligation includes all the territory of the European Union, Switzerland, Iceland, Liechtenstein, Norway, and the United Kingdom. In relation to the exception, we have to take into consideration that in accordance with the third paragraph of Article 2 of Regulation 561, the ATR shall apply instead of that regulation to international road transport operations undertaken in part outside the area that we already saw. And for a vehicle registered in the European Union or in countries which are contracting parties to the ATR for the whole journey, but also to vehicle registered in a third country, which is not a contracting party to the ATR, only for the part of the journey on the territory of the community or of countries which are contracting parties to the ATR. You can see a map with the geographical extension of the contracting parties to the ATR. In relation to the specific exemption to the application of the obligation which was introduced by the mobility package, the regulation on the driving and resting time and the obligation of the installation of the tachograph does not apply in the case of on account and where driving does not constitute the main activity of the person driving the vehicle. For a definition of on-account transport operations, we can make reference to the point D of paragraph 5 of Article 1 of Regulation 1072. All these conditions should be met, and the goods carried are the property of the undertaking or have been sold, bought, let out, or on hire or hired, produced, extracted, processed, or repaired by the undertaking. The purpose of the journey is to carry the goods to or from the undertaking, and the vehicles is driven by personnel employed by or put at the disposal of the undertaking under a contractual obligation, and the vehicles carrying the goods are owned by the undertaking or at its disposal, and such carriage is no more than ancillary to the overall activities of the undertaking. In relation to the second condition, we can make referral to recital 10 of Directive 2022/2561 on the initial qualification and periodic training of drivers, according to which generally driving is deemed not to be the driver's principal activity where it occupies less than 30% of the rolling monthly working time. Thank you for the attention. I give the floor again to Ivan.
Thank you, Luca, indeed, for this thorough presentation on the legislative background. And now I would like to ask Colette Callanan from the Department of Transport to deliver a presentation on the topic of community licensing in Ireland. So, dear Colette, if you could please take the floor.
Thank you, Ivan. As Ivan said, I'm Colette Callanan from the Department of Transport from the Road Transport Operator Licensing Division. And we have 21 staff in the division, and we've responsibility for the regulation of the commercial road transport sector in Ireland. So we issue road transport operator licenses to those operating either road haulage or road passenger transport operations for hire or reward. We also process applications from licensed operators wishing to add, substitute or remove vehicles on their license. And we also issue the driver attestation, COP documents and ECMT licenses. So just some statistics on operator licensing in Ireland. At the end of last year, we had 3,766 licensed haulage operators. 2,436 were involved in international transport operations, with 1,330 with just national operations, and there was 25,420 vehicles in the national fleet. For light commercial vehicles, they came into scope on the 21st of May 2022 by EU Regulation 1055/2020. And these are for light commercial vehicles over 2.5 tonne involved in international transport operations. Currently, we have 289 light commercial vehicles licensed, and they're belonging to 115 operators. 40 of those operators have light commercial vehicles only, and 75 have a mixed fleet of heavy goods vehicles and light commercial vehicles. So I'll go through now the requirements to obtain a road transport operator licence, and these are governed by EU Regulation 1071/2009, 1072/2009 as amended by EU Regulation 1055/2020. We also in Ireland have the Road Transport Act 2011 and two statutory instruments, 265 of 2018 and 208 of 2023. So all operators, whether you're operating heavy goods vehicles, light commercial vehicles, or a mix of both, must have an establishment in the state, be of good repute, satisfy professional competence, and have appropriate financial standing. So for establishment, the rules on establishment were strengthened by EU Regulation 1055/2020 to combat letterbox companies. So every operator must have an establishment in the state with premises where it keeps its core business documents. And these documents are listed in 1055/2020, and we also have additional documents in SI 265 of 2018 and 208 of 2023. They must be registered in the Register of Commercial Companies. That's the Company Registration Office in Ireland. They must be subject to tax, so they must have tax clearance and have a tax number, and the vehicles must be in conformity with the law. And they must effectively and continuously conduct its administrative and commercial activities with the appropriate equipment and facilities at the premises and manage its transport operations with appropriate technical equipment. The Internal Market Information System, as you know, is the mechanism for the exchange of information regarding establishment with other EU member states. So to go through what's required for the vehicles, this is for heavy goods vehicles and light commercial vehicles. So to have them authorised on your operator licence, a vehicle must have current motor tax, that's road taxed in Ireland, and we have a live connection to the National Vehicle and Driver File to verify that your vehicle has valid road tax. They must have insurance covering operations for hire or reward. This is a self-declaration at time of application. They must have a certificate of roadworthiness unless the vehicle is under 1 year old, and we also get that information from the National Vehicle and Driver File. They must have a tachograph calibration certificate, and that's enforced by the Road Safety Authority. And they must have a vehicle registration certificate in the operator's name. That is, unless the vehicle is leased. And we also verify that from our National Vehicle and Driver File database. So for establishment, the RTOL we check now, it's a desk exercise we carry out. So every operator must give us their postcode for their place of establishment and their vehicle operating centres. And we view that on Google Maps. We now have a new functionality in our new IT system since November 2025 that this happens at the click of a button. We also have a connection to the Property Registration Authority, and these show the title deeds, who owns the actual property, so we can check that the operator owns the property. If there is a lease agreement in place, we request a copy of the lease agreement, and we can check that the lease agreement is with the operator and the person holding the title deeds to the property. The Registered Company Registration Office, we get this information from an instant company printout from the Company Registration Office in Ireland. They must be subject to tax, so we have direct access to the Revenue Commissioner's site in Ireland. So we check that they are tax registered and that they have a tax clearance certificate to show that they are compliant and all their taxes are paid up to date. If we are still concerned in relation to establishment, then we can request a premises inspection, and the Road Safety Authority transport officers, they carry out the premises inspections on our behalf, and that is provided for under legislation. So the Road Safety Authority transport officers check the establishment criteria, and they provide a written report back to RTOL. The next pillar that is required is professional competence. So every operator must have a qualified transport manager holding a certificate of professional competence in either road haulage or road passenger transport management. And a transport manager can either have a genuine link to the operator, so they could be a director or an employee of the company, or they could be hired on a contract basis by the operator. Now, if they are hired on a contract basis, there's a limit in the number of transport undertakings and vehicles the transport manager can manage. And in Ireland, that is 4 transport undertakings with a maximum of 50 vehicles. The operator must upload the contract between the operator and the transport manager at time of application. We also hold the Register of Qualified Transport Managers in Ireland. So each transport manager that is put forward for designation on an operator licence is checked via ERU to ensure that they haven't been declared unfit in any member state. And that is the check good repute functionality under ERU. The transport manager is also Garda vetted, that's police vetted in Ireland, and they must complete a declaration of good repute. If they are resident outside of Ireland, they must submit a police certificate from their member state of residence. And since Brexit, and it's probably more relevant in Ireland, the transport manager cannot be qualified in the UK or Northern Ireland, or they can't be resident in the UK or Northern Ireland. They must be resident and qualified in the EU. The next pillar is financial standing, and that was amended by 1055/2020 when the light commercial vehicles came into scope. So for heavy goods vehicle only operators, they must have net assets, capital and reserves in their annual accounts of at least 9,000 for the first vehicle to be authorised on the licence and 5,000 for each additional vehicle. The light commercial vehicle only operators must have net assets, capital and reserves of at least 1,800 for the first vehicle to be authorised on their licence and 900 for each additional vehicle. If you have a mixed fleet of heavy goods vehicles and light commercial vehicles, you must have net assets, capital and reserves of 9,000 for the first vehicle to be authorised on the licence, and then 5,000 for each additional heavy goods vehicle and 900 for each additional light commercial vehicle. So for operators who are trading, they must submit their annual accounts dated within 18 months of the application. And for operators who have not yet traded, they must submit a statement of affairs dated within 1 month of their application. All financial standing documents must be certified by a duly accredited person. That's a practicing accountant who is a member of a prescribed accountancy body, and that's provided for under our domestic legislation SI 398 of 2018. The next requirement is good repute. And in relation to good repute, it's set out in EU Regulation 1071/2009, EU Regulation 1055/2020, the Road Transport Act 2011, and the 2 statutory instruments. So operators must provide the following for every relevant person to allow RTOL unit to assess the good repute. Now, a relevant person are sole traders for the sole trader operators, company secretary directors, business partners and transport managers. So they must do Garda, that's police e-vetting for convictions resulting from a Garda prosecution, and we 100% vet all relevant persons. They must also complete a good repute declaration for infringements and convictions in Ireland or any other member state, the UK or Northern Ireland, in relation to infringements not resulting in a court appearance, that could be fines, and convictions not resulting from a Garda prosecution, that could be revenue convictions, Road Safety Authority, Workplace Relation Commission convictions. Then the RTOL unit, we check the Garda vetting disclosure. So some disclosures come back with nil disclosures, or there may be a list of convictions. We look back indefinitely for serious criminal convictions, and that's provided for under the Road Transport Act. And then we look back 5 years for all other convictions. We also get a report from the Road Safety Authority in relation to any Road Safety Authority convictions. We check the revenue online system to ensure the transport undertaking have tax clearance in place. We check the ERU for ERU reports for any infringements from other member states. And we also check the risk rating, which is provided to us from the Road Safety Authority, who have responsibility for the risk rating in Ireland. And that comes in now automatically to our system since November last year. And then any other relevant information is also taken into account. So when we do an assessment of good repute, one most serious infringement could lead to the loss of good repute. So in accordance with legislation, if there is an MSI reported, we will carry out an administrative procedure to ascertain whether the operator continues to meet the good repute requirement. The administrative procedure is an assessment of the good repute of the operator, taking into consideration such things as all convictions and infringements and their level of seriousness, the frequency of occurrence, all information in relation to Regulation 5 of SI 265, that's to do with their conduct, whether the operator has contravened the terms and conditions of their licence, the need to ensure safety and welfare of other users. We also look at the number of vehicles the operator has in their fleet, the length of time the operator has been operating, and the history of these operations. We examine any representations that we would receive from the operator themselves, from their transport manager or their legal representative, and that could include measures they have taken to ensure future compliance. And we also examine any information from any enforcement authority in Ireland or any other member state and any other licensing authority. And as part of this procedure, we can also request the Road Safety Authority to carry out a premises inspection to assist with our good repute assessment. So once we have gathered all that information, we look at whether we're going to grant the licence. And in Ireland, we usually grant a road transport operator licence for a period of 5 years. However, shorter term licences of 1 to 2 year periods could also be granted in cases where the operator or the applicant has not lost good repute, but they may have convictions and infringements over the last 5 year period. The shorter term licence allows the operator to prove compliance over the shorter term before the licence will be fully assessed again to ensure that the operator continues to meet the legislative requirements. All operators must make a new application at the expiry of their licence, when all the legislative requirements, that is the requirements under the 4 pillars I've just gone through, they're all checked again to ensure the licence can be renewed. The RTOL unit, we also have a monitoring section, and this section checks compliance during the lifetime of the licence, and the monitoring is done on both a random and targeted basis. So if we are refusing or withdrawing an operator licence, the Road Transport Act 2011, Section 5 deals with how the operator can appeal this decision. So a decision to refuse or withdraw an operator licence, it can be appealed by making written representations to the department within 21 days of the notification of the decision. The decision can also be appealed to the district court, and then the judge will make the final decision to agree with the refusal or withdrawal or to grant the licence. These are my contact details if anyone wants them for future reference. Thank you all very much for listening, and I'd like to pass you back now to Ivan. Thank you.
Thank you indeed, Colette, explaining these procedures and the processes. And next in line, it's my ELA colleague Seamus Lynch from Enforcement and Analysis Unit to deliver a practical presentation on driving and rest time rules. So Seamus, if you could please go ahead.
Thank you very much, Ivan. Hope me now. Good morning, everybody. Thank you very much to the previous speakers. My name is Seamus Lynch. I'm currently working on secondment with the European Labour Authority, and I'm very happy to be back here in Ireland today to participate in this webinar, where I will give a basic introduction to the Regulation 561/2006 for operators and drivers of light commercial vehicles. This is not a training, but I hope to cover the essentials that will affect your daily operations, including examples of maximum driving times, mandatory breaks, minimum requirements for daily and weekly rest periods. We've already given this presentation at a previous webinar in December 2025. So we've added some extra slides on this occasion because I want to cover the subject of compensation, where drivers avail of reduced weekly rests. I'm also going to cover ferry crossings, which is obviously going to be very appropriate for drivers and operators based on the island of Ireland. So I think I've got 35 minutes, so we'll dive straight into it. I'm going to start with the limits which are associated with the driving times. There is a daily driving time limit of 9 hours per day. Now, this 9 hours can be exceeded only twice per week. If the driver decides to exceed this limit of 9 hours, he can never exceed 10. In relation to weekly driving time, the maximum limit is 56 hours. In respect to fortnightly driving, which is any period of 2 consecutive weeks, the maximum is 90 hours. Moving on to the mandatory breaks, the rules are that after 4.5 hours of driving, you must take a break of at least 45 minutes before one can resume driving. There is also the option to split this 45-minute break into 2 parts. The first part must be at least 15 minutes, and the second part must be at least 30. Now, an important point to note here is that the second part, the part which must be at least 30 minutes long, this must be taken not later than at the end of the 4.5-hour driving period. Now we move on to the daily rest periods. A regular daily rest period is an uninterrupted period of 11 hours per day. This regular daily rest period can be divided into 2 parts, the first of which must be a period of at least 3 hours and the second of at least 9 hours. This is what we often hear people refer to as the split regular daily rest period. Sounds a little bit complicated, but later on we will show some examples to give you a better understanding of what we mean. Now, there's also the option to reduce a regular daily rest period so as you have to reduce the regular daily rest period to a duration of not less than 9 hours, but specific rules must apply in relation to the number, which I will also delve into in more detail later on. Weekly rest periods. A regular weekly rest must be at least 45 hours, so an uninterrupted period of time of at least 45 hours. This can also be reduced, but to not less than 24 hours in certain cases, and the driver must be compensated for that reduction at a later stage. Now, before we dive into the scenarios where I will explain these rules in more detail, I just want to bring to your attention the symbols associated with the different activities. And you will see these on printouts from the tachograph, which you will also see them in the slides in my presentation further on. Driving time is denoted by the steering wheel. A break or rest period will be indicated by the bed symbol. Other work, which loading or unloading, is denoted by the symbol of crossed hammers, and periods of availability are indicated by the square with the diagonal line. Okay, let's start with some examples of breaks and the rules around the breaks. The regulation says that after a driving period of 4.5 hours, a driver shall take an uninterrupted break of not less than 45 minutes unless he takes a rest period. So let's look at a basic example here. You have a driver drives for 4.5 hours. Under the law, he is now obliged to take a break of at least 45 minutes before he can resume driving again. Now, don't forget, this 45 minutes is a minimum duration. Nothing precludes a driver from taking longer breaks, but this is a minimum requirement. So once he completes this 45, he can resume another period of driving. Okay, and at this point, there's a reset of the calculation of the next 4.5 hours of driving time before he will be required to take the next break. The split option. Remember I said earlier, there is the option to split this 45-minute break into two, where the first break must be at least 15 and the second at least 30. So let's look at an example. You have a driver who drives for 1 hour, decides then that he'll have a 15-minute break. He goes driving again, this time for 3.5 hours. He has now reached 4.5 hours of driving time in total. And he takes his second break, which is 30 minutes. So he's met the obligation in relation to the split break, and he can now resume driving activities again. But once he has taken that second break of 30, he hasn't exceeded the 4.5 hours of driving time. There's a reset of the calculation of the next period of 4.5 hours. Now, third example, I'm going to show you an example where we have the same driving pattern, but the breaks are taken the other way around. So again, he starts off at a period of driving of 1 hour. This time his first break is 30 minutes. Absolutely no problem thus far, because it must be at least 15. And as I said, these are minimum requirements. But then he completes his 4.5 hours of driving time by driving for 3.5, and he takes a 15-minute break. So this scenario here, the breaks are just the other way around. And he goes driving again. This is an infringement. The driver must comply with this strict rule, which says the first part must be at least 15, as it is in this situation, but the second must be at least 30. It's only 15 here, so this is an infringement. So drivers just need to be careful of this particular rule, yeah? Okay, moving on to the, where a break of at least 45 minutes, right, taken in one block, or alternatively, it's taken, the split option is used where you have 15 plus 30. That may be taken before the 4.5 hours of driving is actually accumulated. But this has the effect of, you might hear people using the term wiping the slate clean, and a new calculation will start before you actually reach 4.5 hours of driving. So just to illustrate that in more detail, we have a driver here who starts off by driving for 30 minutes. He takes a 20-minute break, follows this with 2 hours of driving. He is now driven for a total of 2.5 hours, and he takes a 35-minute break. And he resumes driving again. Now, this is the split option. He has satisfied the requirement that the first one is at least 15, the first break. The second break is at least 30. The clock can now be reset. The slate is wiped clean, and there's a new calculation for the next period of 4.5 hours of driving before he would be required to satisfy the break requirements once again. Okay, let's move on to driving time, daily driving time. Regulation says that the daily driving time shall not exceed 9 hours. However, the daily driving time may be extended to at most 10 hours. and not more than twice during the week. So, simple example of this, you have a driver, goes out, drives 4.5 hours, takes his mandatory 45-minute break, follows it up with another 4.5 hours of driving time. He has met the daily driving maximum limit, and he hasn't exceeded it, and he's taken the appropriate break. In the second scenario on the slide, you can see he exceeds 9 hours, which he's allowed to do twice. He can never exceed 10. So in this example, we've 4.5 hours of driving, mandatory 45-minute break, another 4.5 hours of driving, takes another mandatory 45-minute break, and follows it up with an extra 1 hour of driving time, totaling 10 hours. The important thing to note, as I said earlier, you can only exceed 9 hours twice a week. So if you were to drive 9 hours and 15 minutes on Monday, 9 hours and a half on Tuesday, that's it. You've used your opportunity to exceed 9 twice. Now we move on to weekly and fortnightly driving time. The rules around weekly driving time says it shall not exceed 56 hours. The rules surrounding the fortnightly driving time, which means the accumulated driving time in any 2 consecutive weeks, this shall not exceed 90 hours. So let's look at a pattern here of a driver where in week 1 drives for 56 hours, no problem. That's the maximum. In week 2, he drives for 34 hours. When we total the 2 weeks together, the 2 consecutive weeks, we get 90. Fully compliant. Week 3, he drives for 45 hours. No issue with the maximum there because it's 56. You look at the 2 weeks together, week 2 and 3. He's only driven 79, which is obviously less than 90. Again, no issue, fully compliant. Week 4, 45. You add week 4 to week 3, you get 90. No problem either. Week 5, he drives for 50 on its own. No issue with the weekly driving time there. However, when you add it to the previous week of 45, you see that he has a driving time over the 2 consecutive weeks of 95 hours, which is an infringement of the fortnightly driving time rule. Week 6, it goes for 40 hours. Add that to week 5, no issues, 90. Okay, let's move on to daily rest. Regulation says that a regular daily rest period means any period of rest of at least 11 hours. Okay? Of course, it can be more, but if you need a regular daily rest period, it must be of a duration of at least 11. I also mentioned earlier the possibilities of availing of a reduced daily rest period. This means any period of rest of at least 9 hours, but not less than, a period of rest of at least 9, but less than 11, okay? So reduced can never be less than 9. So let's look at a scenario here, okay? A scenario in relation to regular daily rest. We have a driver here who starts his daily working period on a Thursday morning at 8 a.m. And throughout the day, as you can see, there's a number of activities. He's driving. You can see the steering wheel there. It's in the color red. In green, you see there's the brakes, and the orange color crossed hammers. That means he could have been loading or unloading. So across the day, he's engaged in different activities, obviously. His day finishes that evening at 2100. Okay, so that is 21 minus 8. Simply, it's a 13-hour spread. In the industry, you'll often hear people talk about the daily spread. The daily spread is the number of hours from the start of the daily working period to the end of the daily working period. Doesn't mean he was working for 13 hours because, as you can see, there are breaks throughout the day there, okay? But because the spread doesn't exceed 13, there is sufficient time left until 8 a.m. Friday morning, which is exactly 24 hours from 8 a.m. on Thursday morning. Okay, so the important thing here is, and I'll just bring it up on the screen here for you, this minimum rest requirement of 11 hours, right? In terms of a regular daily rest, it must fall within the 24 hours since the resumption of activities after the previous daily or weekly rest period. So it's not enough for the driver just to achieve the 11, okay? This 11 must have been completed within the 24 hours from the start of his daily working period, which in this case was 8 a.m. on Thursday morning. Then, as you can see, at 8 a.m. on Friday morning, once he has completed the 11 hours, he starts a new daily working period. We'll look at another example. Here, the driver starts again 8 a.m. Thursday morning. As you can see, the day is a bit shorter on this occasion. He finishes at 1600 hours on Thursday afternoon. 16 minus 8. We've got a spread of 8 hours. He then takes a daily rest period of 14.5 hours. It's longer than 11. He decides to go working again at 6:30 a.m. on Friday morning. We check to see, is the 14.5, or did he meet the requirement of 11, the minimum requirement of 11 to satisfy the rules around the regular daily rest? Was it achieved within the 24-hour period from the start of the day, which was 8 a.m. on Thursday? And as you can see, it clearly was. No issue. Just to reiterate it must fall within the 24 hours since the resumption of activities after the previous daily or weekly rest period. So, going to now go into the split regular daily rest. Remember at the outset, I told you you could have a 3 plus a 9. Let's see how this looks in a more detailed example. The driver begins his day on Wednesday morning at 8 a.m. He finishes at 2300 Wednesday night. 23 minus 8, we have a spread of 15. Now within that day, we can see that there is actually one uninterrupted period of rest lasting 3 hours. Okay? So from 2300 on Wednesday, you can see up until 8 a.m. on Thursday morning, he is able to take an uninterrupted period of 9 hours. And then he starts a new day on Thursday morning at 8 a.m. So what we want to double check here now, we've said earlier, a regular daily rest can be taken in split fashion, where the first period must be at least 3 hours uninterrupted, and the second period at least 9 hours uninterrupted. The diagram here, that clearly is the case. But what we want to check is, did it fall within the 24 hours from 8 a.m. on Wednesday morning? And yes, it did. So there's no issue here. Okay, let's move on to a reduced daily rest. Okay, we've covered regular. Now we go to reduced. On this occasion, the driver starts his day at 8 a.m. Monday morning. He works right up to 2300 Monday night. 23 minus 8, just to check his spread. The spread is 15. Now, straight away, this is good, because if we're talking about we're talking about reduced daily rest and taking into account the 24-hour rule, 24 minus 15, we know he has sufficient time within the 24 hours to comply. So as you can see there, once he has the 9 hours taken, it's exactly 8 a.m. Tuesday morning, which is exactly 24 hours from 8 a.m. on Monday morning. He can now start a new daily working period, and he's in compliance with the rules. So just to kind of maybe summarize this rest requirements for you. If the driver is in a position where he needs to take a regular daily rest of at least 11 hours, well, then the spread, his daily spread, yeah, from the start of the day, the end of the day, cannot exceed 13 hours. Because he needs to have 11 left to expire after the 24-hour period. For reduced daily rest, the spread cannot exceed 15. That's the case here. 15 plus 9, 24. Everything, all is in order, yeah? Oh, yeah, and the condition, I almost forgot, sorry. A driver may have at most 3 reduced daily rest periods between any 2 weekly rest periods. This is the rule associated with the reduced daily rest period. There's a maximum number of times that a driver can take it. It's 3. Well, 3, it doesn't say 3 per week, because sometimes a driver may take more than 1 weekly rest. But anyway, if I take a simple example of where a driver, he rests every weekend. He only works Monday to Friday. Every weekend he's off on a weekly rest Saturday and Sunday. Well, on Monday evening, he could take a reduced daily rest period. On Tuesday evening, he could have another reduced daily rest period. On Wednesday evening, he could have a 3rd reduced daily rest period. But now on Thursday and Friday, he needs a regular. Okay, that's it in its simplest form, okay? Now, another example of reduced daily rest. Monday morning is the start of the daily working period at 7 a.m. It finishes 2300. 23 minus 7 is 16. Now you know he's in trouble, yeah? Already. He's now in a situation where he cannot comply. Yeah? Because 16 plus 9, he needs a 9 in this case. This is the example I'm using, right? Once he's completed the 9, it's 8 a.m. on Tuesday morning. Now he has a problem. Problem is he failed to achieve the 9 hours within the 24-hour period from the start of his day, which was 7 a.m. on Monday morning. So this is an infringement. So drivers need to be careful, even though you might meet the threshold of the duration of the rest period, right? It must fall within the 24 hours. So it's a very important point to remember. Now we move on to weekly rest. I want to get even a little bit more complicated, but let's first of all see what is a regular weekly rest period. It means any period of rest of at least 45 hours. So an uninterrupted period of rest lasting at least 45 hours. A reduced weekly rest period means any period of rest of less than 45, which may be shortened to a minimum of 24. It can never be less than 24. Now, we're going to look now at the frequency of weekly rests, okay? Because there is a rule that says that driver is required to start a weekly rest period no later than at the end of 6 24-hour periods from the end of the previous weekly rest period. Sounds complicated, but I'm going to show you a pattern, a 6-week pattern here of a driver, right? And we're going to just then analyze it to see if he meets this requirement. In week number 1, we find a regular weekly rest period of 45 hours. Week 2, it's reduced, 24. Week 3, he takes another regular weekly rest period of 45. Week 4, reduced, 24. Week 5, another reduced 24, and week 6, we have a regular weekly rest of 45. Now, just going to, at the outset here, we just want to check where all of these weekly rest periods started no later than at the end of 6 24-hour periods from the end of the previous weekly rest. And as you can see quite clearly, yes, they all are. And the one, if you look at I would just choose one, the week 4, the end of week 4, and the start of week 5. That was where he maximized the 6 24-hour periods. There's exactly 6 24-hour periods there between the end of week 4 and the start of week 5. All the others fell even They were started earlier than 6 24-hour periods. So there's no issue with the frequency, okay? Now, what we're going to look into after this is the compliance with further rules, right? So I'm going to explain to you the first rule here. It's called the 2-week rule. And according to the regulation, this 2-week rule says that in any 2 consecutive weeks, a driver shall take at least 2 regular weekly rests or 1 regular weekly rest and 1 reduced weekly rest. Okay? Now, let's go back and look at this guy, same guy. So we're looking at the same pattern. We're happy with the frequency. There's no issue as regards the starting time of any of these weekly rest periods. But what I want to check now is, has he complied with the 2-week rule? Well, let's look at week 1 and 2. Find 1 regular and 1 reduced. No problem. Box ticked. Now let's look at week 2 and week 3. 1 reduced and 1 regular. Very good. Box ticked. Week 3 and week 4, 1 regular followed by 1 reduced. Again, we're compliant with the 2-week rule. Now we're going to examine week 4 and week 5 together. And here we see 2 consecutive reduced weekly rest periods. This does not comply with the 2-week rule. 2-week rule doesn't allow this. So this is an infringement at this point, right? I have another 2 weeks to check. So let's do this first, week 5 and week 6. I see 1 reduced and 1 regular. No issue. Now, so thus far we have found a problem with weeks 4 and 5. But I just now want to explain a specific derogation to you, okay? Second now, moving on. Yeah, that's just to make sure in every 2 consecutive weeks there are at least 2 weekly rest periods and that one of them is regular. So we've done that. We found an issue with week 4 and 5. But before we go any further, I want to explain a derogation which was introduced by the mobility package in relation to this 2-week rule. This derogation says that if a driver is engaged in the international transport of goods outside of the member state of establishment, he may take 2 consecutive reduced weekly rest periods, but with certain conditions attached. So he's outside of his member state of establishment, takes 2 consecutive reduced weekly rest periods. We then have to look at this in any 4 consecutive weeks. We must be able to find at least 4 weekly rest periods. That's condition number 1. Condition number 2, at least 2 of these 4 shall be regular. Okay? So in any 4 consecutive weeks, we must find 4 weekly rest periods, and 2 of those must be regular. So let's go back and look at this guy's pattern again, yeah? So I'm going to select this 4-week period, yeah, because we have an issue with week 4 and week 5. So looking back over the previous 4 weeks, we need to find, first of all, the first condition, is there a weekly rest in each week? The answer, yes, there is. First condition, he's complied with it. Now I want to find 2 regular weekly rest periods in this 4 weeks. Can I find 2? No, I can only find 1. And because there's only 1, this driver is not allowed to avail of that derogation to take 2 consecutive weekly rest periods. So we have an infringement of the 2-week rule. There it is, simply put, the driver had taken only 1 regular weekly rest in 4 consecutive weeks, starting from week number 2. Okay, I'm now going to talk about compensations, okay? Because, as I said earlier on, where a driver takes the option of a reduced weekly rest period, he must be compensated. And there are rules around these compensations. So first of all, the compensation must be paid back in full. it must be taken in one block before the end of the 3rd week after week concerned. It can be added to another rest period of at least 9 hours. So in other words, if you were due 21 hours, for example, of compensation, you could add it to a daily rest period of 9 somewhere before the end of the 3rd following week. So let's look at an example. Okay, I'm going to show you a 4-week pattern here. Week number 1, the driver takes a reduced weekly rest period. In week number 2, he takes a regular weekly rest period. In week 3, he takes another regular weekly rest period. And in week 4, he takes another regular weekly rest period. So he needs to be compensated for week 1. 21 hours, 24 plus 21 is 45. So he's got to be compensated for this reduction. What does the rule say? The compensation must be paid back before the end of the 3rd following week. The 3rd following week after week 1 is obviously week 4, So we're looking to find compensation before the end of week 4. I'm going to just show you an example of how this might work. So what I'm saying is this driver has to be compensated for the 21 hours of a reduction, which he owing from week 1. It must be paid back before the end of week 4. As I said earlier, it can be added to another rest period, which is of at least 9. So I'm going to show you an example here of week 4, where the driver took a reduced daily rest period of 9 hours because he was entitled to it on this particular date. He adds 21 to it, to compensate him for the reduction in week 1. And now he's fully compliant. So this is how compensation should work in relation to weekly rest. But there is a different rule around the compensation for a scenario where a driver avails of 2 consecutive reduced weekly rest periods. Now, the example I showed you earlier in relation to 2 consecutive weeks, it wasn't compliant. He didn't fulfill the conditions, so he wasn't allowed to avail of 2 consecutive reduced weekly rest periods. But just let's say that he satisfied the conditions, he was able to avail of the derogations, and he took 2 consecutive reduced weekly rest periods. I'm now going to show you the rule around the compensation in that type of scenario. The regulation says that where 2 reduced weekly rest periods have been taken consecutively, the next weekly rest period shall be preceded by a rest period taken as compensation for those 2 reduced weekly rest periods. So week 1, we've got a regular weekly rest period of 45 hours. Week 2, a reduced weekly rest period of 24 hours. Week 3, a reduced weekly rest period of 24 hours. And week 4, a regular weekly rest period of 45 hours. So compensation due for week 2 of 21 hours, and week 3, another 21 hours is also due for compensation. How should this be done? Just look at the text above before I hit the clicker. The next weekly rest period must be preceded by a rest period taken as compensation. So if I move these 2 21s down to line 4, week 4, now this is how the compensation should look. You have 21 plus 21 plus 45, 67 hours. This driver will have to get 67 hours in the week immediately following the 2 consecutive reduced. And that compensation, the 21 plus 21, must be taken within the 624-hour period from the end of the reduced weekly rest in week 3. Because the regular weekly rest period of 45, if you remember from earlier, must start no later than 6 24-hour periods from the end of the previous weekly rest. So if I just step back there for a moment, that 45 in week 4, as you can see, clearly starts no later than 624-hour periods from the end of week 3. So there's no issue with the frequency here, okay? No issue with the start of the resting times. But now now we want to make sure is the compensation also is taken at the right time. There you go, week 4. Little bit complicated, but very important for international drivers who may avail of this particular derogation. Okay, now to finish up, right, I've got a couple of slides on ferry crossings because obviously Ireland is an island and anybody engaged in international carriage is going to need to get on a ferry. So I'm just going to highlight 2 particular ferry crossings here, one from Dublin to Holyhead in Great Britain, and the other one from Rosslare, southeast of Ireland, going to Cherbourg in northern France. Now, if everybody understood me earlier when I was talking rest, I was talking about daily rest periods, weekly rest periods. I always said that they were uninterrupted periods of time. But I'm now going to tell you about a specific derogation which is granted under Article 9 of the Regulation 561/2006. And this derogation allows for an interruption of a regular daily rest period or a reduced weekly rest period or a regular weekly rest period for the purposes of embarking or disembarking from a ferry or train. This is the only time that a rest period can be interrupted, okay? Ordinarily, it's an uninterrupted period. So let's look at Dublin to Holyhead, okay? The driver, he starts his day on a Monday morning at 7 a.m. Here's his activities throughout the day. His day finishes at 1900. You remember what we did earlier? Let's go 19 minus 7. The spread is 12. Quite happy that this guy will be able to achieve 11 hours because that's the minimum regular daily rest period. And I'm quite happy that he'll be able to take it within 24 hours, from the start of the day at 7 a.m. So let's have a look at what this would look like if he was going to take part of it on a ferry. So he starts off, as you see, the end of his day now was at 1900. So at 1900, he starts his regular daily rest period. So after 4 hours of rest, he interrupts it to get onto the ferry in Dublin, going to Holyhead. So there's the interruption, as you can see, between the 2 blocks of 4. And that interruption is made up of some driving and some crossed hammers. I'll explain a bit more about that in a second, okay? He gets off the ferry at the other end, so we have another interruption. And he now rests for another 3 hours. 4 plus 4 plus 3. He has achieved 11 hours. He has done this within 24 hours from the start of the day at 7 a.m. on Monday morning. And he's ready to start a new day. But what the important part here now is, right, there are conditions around the eligibility for taking this derogation, okay? First of all, the rest, the purpose is to interrupt your rest is to embark or disembark from a ferry or a train. The maximum number of interruptions allowed is 2. These 2 interruptions cannot total more than 1 hour. Okay, so 1 hour, that's the maximum. Don't fulfill these conditions, well then normal rules apply. And the regulation also says that during this regular daily rest, the driver must have access to a sleeper cabin, bunk, or couchette. I'm going to show you another example now. This is quite similar. It's just the other way around. This time we're starting in Holyhead. Driver starts his day in the UK. It's at 9 a.m. He finishes at 2100. 21 minus 9, just to make it easy for ourselves, is 12. begins his daily rest period at 2100. He interrupts it after 4 hours to board the ferry. Ferry crossing is 4 hours. Another interruption because obviously he has to drive off, and he completes his 11 hours. 4 + 4 + 3, 11. The time is 9 a.m. Friday morning, right on the button of 24 hours from 9 a.m. on Thursday. The driver is compliant. So these interruptions, right, as you can, yeah. If you're in a line of traffic getting onto a ferry, if you're in a line of traffic anywhere, right, obviously it could be stop start. So the tachograph will record driving for parts of it, but there'll be part of that stop start, if you like, that'll show crossed hammers, because the default position of the tachograph when the vehicle is stationary is crossed hammers. Yeah. So, but that's okay. This rest period can be interrupted by other activities, which include obviously other work. Could be a shorter break of, by the way, breaks are shorter than 15. They don't qualify as breaks. But the point is, this regular daily rest period can be interrupted for the purposes of embarking and disembarking, provided the interruptions don't exceed 2, and provided the total time of the interruptions does not exceed 1 hour in total. So, and very important, driver must have access to a sleeper cabin, bunk, or couchette. I think this is my last slide. I just wanted to show an example from Rosslare to Sherbrooke, because obviously it's a longer crossing, just to give you an idea of what this might look like. Yeah, so on Saturday morning, this driver ends his daily working period at 5 a.m. in Ireland, okay? And he wants to take a reduced daily rest period. Ordinarily, of course, this can't be interrupted, but he wants to get onto a ferry at a particular point here. So he's allowed to interrupt, provided he's satisfied. He can interrupt this reduced weekly rest period. So in this example, after 12 hours, as you can see, the movement indicated by the tachograph, there's a bit of driving, there's a bit of crossed hammers. It doesn't exceed 1 hour, or maybe it might just be on the button. I'll show you in a minute. The ferry crossing takes 18 hours in total. He gets off at the other end in Sherbrooke at 12 midday on Sunday. And as you can see, the 31 hours there from the start of his reduced weekly rest at 5 a.m. to the end of it at midday on Sunday. And this clearly shows us that the interruption was only for 1 hour. There does not have to be 2 interruptions, by the way. It's up to 2 interruptions. In this case, there's only 1 interruption, and the 1 interruption does not exceed 1 hour, so the driver is compliant. I think, yeah, and he can start his new daily working period. I think that's my last one, Ivan. Yeah, just to recap, rest may be interrupted in order to embark or disembark from a ferry or a train. Maximum 2 interruptions allowed, up to 1 hour in total. And the driver must have access to a sleeper cabin, bunk, or a couchette. Yeah, that's the last slide. I probably went over time, but sorry about that. I'll hand the floor back to you, Ivan. Thank you.
Thank you, Seamus. Thank you for this, again, detailed presentation. And please keep your camera on, because it's time for the first Q&A slot, and we will need you to help us with this one. So, as I mentioned before, we did receive questions in advance, and we would like to dedicate some time now to answer to some of the most relevant ones on the previously covered topics. I would like to ask our expert speakers to please be prepared to help us with the questions which we have prepared for this group. I will read the questions out loud. Since we are slightly behind the schedule, we will try to cover as much questions as possible in this Q&A slot. Remember that we have yet another Q&A slot later on. Okay, so let me start with the first question, and as I mentioned, I would kindly ask Seamus to help us with this one. So Seamus' question reads the following. An LCV is registered in an ATR country and performs an intercommunity journey between 2 member states where it loads and unloads. Does it need a tachograph and to comply with Regulation 561/2006?
No, the simple answer is no, right? So if you, as Luca pointed out earlier, he had a slide there which showed us Article 3, Paragraph 1 of the Tachograph Regulation 165/2014. So this the extension, if you like, of the regulations to LCVs does not apply. It only applies to vehicles registered in the EU.
Perfect. Thank you, Seamus, for providing the clarification on that one. And the next one is sort of similar. So an LCV is registered in an EU member state and exclusively performs international transport between a member state and an AETR country and vice versa. Does it need to be equipped with a tachograph?
I would say no, because but what's important here is that you said he's exclusively engaged, yeah, in
exclusively performs international transport, yeah.
Yeah, with an AETR country and vice versa. So basically, he's not carrying out any international operations within the EU. So the answer is no.
Perfect. And we have yet another one. So an LCV performs international transport in own account from member state A to a member state B. Driving is the main activity of the person driving the vehicle, and the journey is longer than 100 kilometers. Does this use case fall in scope of Regulation 561/2006, and is a tachograph needed?
Okay, own account. What's important to point out here, right? Own account is in scope of the driving and resting times. Okay, it always has been. For HGVs, commercial carriage, if you like, there's two subheadings. You've got higher reward and you've got own account, both of which are in scope of the driving and resting times. However, in relation to light commercial vehicles, there is an exemption provided for under, and again, I think Luca showed this on his slides, under Article 3HA. It provides for an exemption for LCV operators who are engaged in own account, provided that driving is not the principal activity of the person driving the vehicle. So from what you said there, there was also the 100 kilometers I don't think is relevant here, yeah? Because if we look at Article 3HA, it's specifically for light commercial vehicles engaged in own account where driving is not the principal activity of the person driving the vehicle.
Okay.
Okay, that's the answer to that.
Perfect, Seamus. And another one is an LCV performs international transport for hire or reward from member state A to member state B. Since when should the driver card be inserted and the tachograph data recorded? From the beginning of the journey or from the border crossing?
The driver card should be always inserted at the start of the daily working period before commencing the journey. Additionally, I might add that where a driver finds himself having been engaged in specific activities not recorded by the tachograph before he gets to his van, for example, let's say he's engaged in office work, or he could be loading, unloading, he could be washing the vehicle, and he doesn't have his card inserted while he's doing all this. When he gets into the vehicle, inserts his card into the tachograph, he will actually be asked, was he resting until now? So the answer will be no, and he will have to make a manual entry to reflect the time spent engaged in the activities of other work. So yeah, it's very important that the card is inserted at the start of the daily working period.
Perfect. Thank you for explaining that as well. And the next one is also regarding the tachograph. The question is, what should the driver do if the tachograph malfunctions in the middle of an international trip? And on top of that, do they get a fine?
If a tachograph breaks down in the middle of an international trip, okay, the Article 37 of the tachograph regulation deals with this, right? And it says that in the event of a breakdown or faulty operation, right, the undertaking shall have it repaired by an approved fitter or workshop as soon as circumstances permit. However, if that vehicle is unable to return to its premises back at home within a period of 1 week, calculated from the day of the breakdown, that repair should be carried out en route. Okay. Now, it's also important to note that during this time, while the tachograph is unserviceable or it's malfunctioning, okay, the driver needs to be making some kind of a record of his activities for the day. That's very important. I mean, he can do that. It depends in what way it's malfunctioning. If he's able to take a printout, right, he can make this record on the back of the printout. There's actually, I think, a feature in the back that which allows you to make this record. But it is important that they make some kind of a temporary record during this period of time. As regards the fine, that's up to each individual member state. Each individual member state has full competence over what kind of fines that they issue for each specific infringement. But I would just like to point out that this particular infringement, right, if the driver doesn't comply with the rules as set out, there's a specific regulation, it's regulation 403/2016, which categorizes all these different groups of infringements. This particular infringement would be categorized as a very serious infringement. And as I said, the relevant fine is determined by each individual member state. Yeah,
Okay.
that's that one, Ivan.
Thank you, Seamus. Thank you. I would suggest that we now make a short break. Welcome back, everyone. Welcome back to our ELA live information session. We are continuing our event, and it is my great pleasure to invite my colleague Ivona Kašpiksova to present on the topic of posting of drivers. Ivona, please, the floor is yours.
I hope that everyone hears me well, and I can start with my presentation on posting of drivers. So it's always good to be presenting after driving and rest time, because in that perspective, posting doesn't seem that difficult. But in case after our presentations you think that this is still difficult, it's not. If you just repeat these rules every day, then they become quite easy. So just bear with us. You know, we have a lot of materials, as Monica said. This is not our first session. There is a lot of available materials already on YouTube. You can rewatch them, listen to our voices throughout the year. And I think in the next 2 months before the rules actually apply, you'll be able to face them. But of course, jokes aside, we are here to explain in detail the rules about posting of drivers. And I will tell you, we would learn 3 elements today. So first, we will see what are the rules and what is the legal basis for these rules, okay? Especially here in Ireland, there is an additional interesting legal basis, which is, of course, the TCA agreement, which is interesting to, let's say, to the operators operating in this geographic area. And the second part, which we will learn today, will be the types of operations that are covered or not covered by posting rules. So we will see some maps. We will try to identify where and if the posting starts and when it starts or when it finishes. Okay, so there are important elements on these maps to spot. And last but not least, we will try to see the enforcement which is divided between the roadside and then the online part through the IMI system. So 3 elements to learn today. Let us start. We will start with the rules, okay, with the legal basis. And here I would like to underline a few disclaimers. First of all, what I will show throughout the whole presentation only refers to the transport of goods, okay? So it's important, all the scenarios and the operations I will be referring to, it's on the transport of goods, freight transport, because as you heard today, this presentation is part of the campaign directed to the LCV operators, light commercial vehicles, and the rules applicable to them from the 1st of July only regard the transport of goods. Second disclaimer, we are talking about drivers to whom the posting rules apply, who are directly employed by the operator. Okay, there could be some categories of drivers that you might identify at the roadside, or you might have in your companies, who are either self-employed, and these rules do not apply to the self-employed drivers, or they might be actually employed by a temporary employment agency, okay, or assigned to the operator through intra-group posting. So these categories are not covered by the posting of drivers rules that I will be presenting today. This is important, okay? And the third disclaimer is that most of the rules I will be presenting today come directly from the 3 directives listed in front of you, but there will be some elements that regard the enforcement, let's say, of these rules, but also the moments in which we start or finish posting that are not specified within the directives, but they come from the quite substantial materials, guidance materials adopted by the Commission. We call them the scenarios on posting in the in transport of goods, okay? And these materials are all available to you, publicly available at the website of the European Commission, okay? So we will try to make sure you have in the materials after the session, you have all the links, relevant links, in order to get acquainted with them before the 1st of July. Okay, so let's see the basic rules here. As you can see, posting of workers is not new legislation. Posting of workers first directive was adopted in 1996. Then it was revised in 2018. However, the basic core rules apply from 1996. So quite, let's say, I could say even old rules. This is not a new phenomenon, posting. And in 2014, these rules were strengthened through enforcement directive. Okay, you can see in the middle, the enforcement directive precised enforcement practices that are applicable to companies which post workers. In 2020, and even of course in the period leading to adoption of the lex specialis, so in other words, special rules that apply to posting of drivers, it was discussed broadly that certain enforcement practices that are applicable to so-called stationary posting are quite difficult to apply also in road transport. So it was decided that we should actually maybe adopt specific rules for the posting of drivers that would describe more precisely what are the enforcement practices at the roadside to take away the burden of the enforcement from the driver and everything what is happening at the roadside to, put some of the elements to the so-called back office. So in order to, then enforce the remuneration, the right remuneration of the driver, we would not ask the driver himself at the roadside to provide pay slips or employment contracts, but we would rather ask for these documents online through the IMI system. So these were, let's say, the discussions that led to adoption of the Lex Specialis in 2020, together with, of course, all these scenarios and all these rules that cover one type of operations with posting and the other not. Okay, so let's see what are these posting rules about actually. So you can see a definition of a posted worker that again is there since 1996, which says a posted worker is a worker who for a limited period of time carries out his work in the territory of a member state other than the state in which he normally works. So let's take an operator, let's say from Ireland, who would like to deliver goods or go and pick up the goods to deliver back to Ireland, okay? So if he goes to deliver the goods abroad, then of course this operation would, if this operation is done with the driver who is directly employed by this operator, then it means that the driver would for a limited period of time be carrying out work in another member state. Okay, and this is exactly where the posting rules could apply, but we will see in details which kind of operations are covered and which are not. So again, there has to be an establishment of a company in one of the member states where the driver, let's say, is would be covered by the labor related rules when it comes to his employment contract, okay? And then for a limited period of time, he would be performing his work in other member states. And that's where posting rules could be triggered. Okay, so in 2020, there was an adoption of the so-called Lex Specialis that in Article 1 are entitled specific rules on the posting of drivers. Okay, so in total, you will have 3 directives that speak about posting, but 1 directive from 2020 that speaks about the posting of drivers in the road transport sector. Okay, and when it comes to posting to and from UK, there is an additional, let's say, legal basis, which would be trade and cooperation agreement, which only refers to road haulage operators. Okay, so again, freight transport, that specifies concrete, let's say, conditions and specified what posting is. And in really basic terms, you have to understand that the TCA treats the EU member state as a one party, okay? And UK is a one party to this agreement. All the member states are another party to this agreement. That means that the operations between these 2 parties are considered to be almost, between these parties are considered to be bilateral, okay? So it's important to see it in this perspective. In the meantime, as I said, you not only rely on the directives, but also on quite extensive materials adopted by the European Commission, which are available again on the Commission websites. But ELA, European Labour Authority, also prepared materials that should guide you in these, especially in the coming 2 months to get acquainted with the rules, but also after that, of course, to keep applying them. So you can see on the screen a leaflet that was prepared under the campaign directed to the light commercial vehicles, telling you why might you be entitled to a higher pay when you are a posted driver. So indeed, we have just seen who is a posted driver, so the person who for a limited period of time carries out his work in another member state. But then the question is, so what does this posting actually consist in? So the posting rules should sort of protect the driver and grant him a remuneration of the other member state the moment he's actually posted to that other host member state, only if these rules are more favorable to the driver. So in no situation could the driver be treated worse than what his labor contract already grants him. So it's important that, of course, this is just application of more favorable treatment to the worker. Here on the screen, and of course, in general terms, we mostly refer to remuneration. It's quite a, let's say, difficult word, but in very often exchanged with the words like wage or pay. However, it's important to stay on the legal terms. Remuneration covers also additional benefits or allowances that are applicable in the host member state. So it's important to speak about also pay that goes beyond just the minimum wage. So here, it's the posting of a workers directive do not only grant this protection to the worker in terms of remuneration, but they also cover additional elements. However, it's been, as I said, always treated as if the remuneration was the most important element of all these additional terms and conditions of employment. All right, let's go then maybe further to see the second part of the presentation, which are the transport operations that could be covered or not covered by posting rules, okay? Here on the screen, I would like to just underline, you can also see, except for ELA logo, you can also see Corte logo. Corte is a sector-specific organization with whom we did we prepared these slides. So this is also to recognize their input in this presentation. So let me just go one by one through these types of operation, and we will then see them on the maps so that it's easier for you to grasp what I'm, the definitions that I'm just showing. Okay, bilateral international transport operation, okay? In simple terms, it means that an operator, okay, with help of the driver, so the driver is driving the truck, would be delivering goods from or to his member state, okay? So whenever you're transporting goods from your member state or transporting goods to your member state, that could be considered a bilateral operation. So one of the member states concerned under this operation is the member state of establishment of the operator. Transit. Transit is when you're just crossing a member state without any loading or unloading. And these two types of operations, bilateral and transit, well, transit is not an operation, it's just crossing the member state. These are not covered by posting rules. Okay, so you can see them in green. Then we have an expression which says cross trade. This is not legal term that you could find in any of the directives. In the directive, if you happen to read them, you will only find non-bilateral transport operation, international transport operation. Okay, so cross trade, in order to shorten it a bit, we use this expression, but it is a non-bilateral international transport operation. That means that it's done between two member states, none of which is the member state of establishment of the operator. Okay, so you're not transporting goods home or from home, you're transporting the goods between two other member states. This is cross trade. All right, and then this type of operation is covered by posting rules by default. Cabotage, when you are actually performing operations, domestic operations, so domestic transport in another member state, where loading and unloading takes place in another member state, which is not the member state of establishment of the operator, is also covered by posting rules. And then we will see different application of posting depending when it comes to unladen journeys, depending of what is the unladen journey leading leading to. So whether it's leading towards an operation which will be covered by posting rules, or maybe the unladen journey is an unladen journey home. Okay, and then the posting would not apply. So before I show the maps, let us just describe the symbols used. Okay. Laden journey will be described with a normal line, unladen journey with an interrupted dots, okay, interrupted line, then a sea leg of a journey with these blue interrupted lines. Loading will be indicated with a letter L, okay, and depending on the number of operations, you will see where the loading will take place, indicated by L, unloading with U, and then indication of the operator's member state of establishment will be on the left upper corner, with of course abbreviation of the member states. Roadside check might pop up on some slides, but that is not now important for you. All right, so let us go towards the first operation to see that on the map. As said, bilateral international transport operation is not covered by posting, and this is an operation where an operator is performing a transport from or to his member state of establishment. Okay, let's see that on a map. So I will continue with this pattern of showing always the member state of establishment of the company in the upper left corner. Okay, this is a fundamental information because that is an element that actually then triggers posting or not, okay, depending on where the operations take place. So we will show now a bilateral operation performed by Italian transport operator. Okay, so let's see where the loading takes place. In Italy, this is the member state of establishment of this operator. Then the load is transported from Italy to France, where unloading takes place, after which unladen journey goes towards a loading place in France, loading in France, and then the goods are transported back home to Italy, unloading in Italy. Okay, these are two typical bilateral transport operations. That means that this entire route will not be covered by posting rules. If it's not covered by posting rules, the driver does not need any posting declaration to show during the possible roadside check if he's being stopped by any inspector. Okay, so that's important. This is a operation completely not covered by posting rules. Okay, let's go further. Transit. Okay, so what happens when we are transiting? When there is no loading, no unloading in a member state through which we're transiting. And that could happen, of course, under a type of operation that could be bilateral, not bilateral, but it's important to understand that now on the map, we see a member state of establishment is Slovenia. We see the name of the operation, bilateral operation with a transit leg. Okay, so the loading takes place at home, sort of the operator, so member state of establishment. Then the driver is transiting through Italy to unload in France. Okay, so what is important here? This is a bilateral operation, so entirely not covered by posting rules. And what happens in Italy? In Italy, there is only transit. Transit is also not covered by posting rules. Okay, so entire route not covered by posting. Okay, let us see the first operation that would be covered by posting rules. Okay, so cross-trade, again, this is a transport operation between two member states or member state and a third country, none of which is the country of establishment of the operator carrying out these operations. So on the next map, what we will see is that not only if posting applies, and we know that this is a cross-trade, so posting will apply, but also when will it start applying. Okay, so this is exactly what I said would be specified in the guidance materials provided by the European Commission. So following the pattern, we see the member state of establishment of the operator, which is Portugal. Okay, so we start in Portugal, but the operator goes unladen to Spain, where he loads, okay, loading one, and then he goes towards France with a load where unloading takes place. Then he goes unladen to another location in France, loads a load in France, unloads in Spain, okay, and then goes back home to Portugal unladen. So both operations, L1, U1 and L2, U2, are cross-trade operations because they happen between Spain and France. And this is not the members, these two are not member states of the operator. Okay, so operator performed two transport operations between two member states, none of which is his member state of establishment. Cross-trade, typical cross-trade, posting rules should apply in this situation on that scenario. The question is now, when will we start covering the driver with posting rules, okay? So the rules of posting will be, of course, applicable to each member state concerned. Okay, so now we see that the posting starts at the border. One could say, why at the border? Why not when he starts? Well, because he's Portuguese operator, you cannot be posted to your own member state. So obviously posting cannot apply in Portugal because in Portugal, this driver is covered by Portuguese terms and conditions of employment, okay? So now he crosses the border with Spain, going unladen towards an operation which is covered by posting, and that's why the rules apply from the very beginning when crossing the border. So he will start to be posted to Spain, okay, to Spain, the moment he crosses the border. I will now show you where the posting finishes, but let's see where it finishes. It finishes at the unloading. But what is important here, because you could, for the driver to know that he will actually be posted to two member states. So first member state will be Spain. Practically the posting to Spain will finish at the border with France, and that's the moment where he will start being posted to France, okay, at the border between Spain and France. And then when after the unloading, he will go towards another operation which will be covered again by posting rules. So the unloading part of his unladen part of his journey will also be covered by posting to France, okay? And then he will restart being posted to Spain once he crosses back to the border, going towards the unloading in Spain. Okay, the posting rules will stop applying with the unload this time because the unladen journey towards home will not be covered by posting, okay? So far, so clear, I hope. If there are questions, remember about the Slido possibility to ask questions. And then let us see a cross-trade operation between third country and a member state, because these could also happen. So we see a load taking place in Ukraine, then a transit through Poland, and then unload in Germany. As always, you can see the country of establishment in the upper left corner. This is Netherlands, okay? So if a Dutch operator is performing this operation, we know that a cross-trade is covered by posting, but the question is now, when will the posting rules start applying, okay? From which moment? So we know that in Poland, it's just transit. So transit will not trigger application of posting rules to Poland, okay? So he will not be posted in Poland. Can he be posted in Ukraine? Well, Ukraine is not a member state, so posting rules will not apply in third countries. You know that, of course, UK is a specific situation, but in most of the other countries it will not apply. And then the only country where we could start actually applying the posting rules will be Germany. Germany, because this is a Dutch operator, okay, not German operator. So he's doing an operation between countries, none of which he is his country of establishment again. And that's why we start applying the posting rules from the moment he crosses the border with Germany. Okay, that was cross straight. And let us see, of course, the end of the posting in this situation on this map, and this operation stops with the end of with the unload. Okay, that's a cross straight. Let's see cabotage. Cabotage is domestic transport operation carried out entirely in another member state. But there are some concrete rules and concrete limitations that I will not discuss today. However, you know that you have to be doing an incoming international transport operation before starting cabotage. So let us see that all. I will just show you the entire route. Okay, so here we see that the operator is coming from Italy. Okay, it's an Italian operator who performed a transport operation L1U1 from Italy to France. Okay, that transport operation is a bilateral transport because the operator is from Italy. After that, he went unladen to a pickup point in France to pick up goods and then deliver them in another location in France. And he did that 3 times. Okay, so 3 cabotage operations in France, after which he comes back unladen to Italy. So let us see where exactly, in which moment would we start applying posting to France, because we know that cabotage rules do trigger application of posting rules. Okay, so one could say, why don't we start at the border? Well, we don't start at the border because the first operation was bilateral, and bilateral operations are not covered by posting rules. Okay, so after the bilateral operation, when he was going unladen towards an operation which will be covered by posting rules because it's going to be in a cabotage operation, the posting will start the moment he starts driving towards that operation. Okay, and that's exactly where the posting, you see that on the map, it will start applying from that moment. And then it will finish with the unload of the 4th operation here on the screen, because after that, the driver continues unladen towards home. Okay, home of the operator, of course. All right. If a journey with a load is subject to the obligation to post driver, the obligation also occurs during the preceding journey without a load. You can see that on the screen. Combined transport, we don't have a map here, but I just wanted to mention that combined transport is also mentioned in the Lex Specialis directive. So let's see, as you know, the road transport could be, transport operations could also foresee part of the operation taking place by rail, inland waterways, or maritime services. As you can see on the map, there is an initial road leg and a final road leg with no more than 150 kilometers in a straight line, and the part in the middle, let's say done by rail, inland waterways, or maritime, is at least 100 kilometers, okay? And if these conditions apply, then you could actually speak about combined transport, and directive on Lex Specialis foresees application of posting rules to combined transport in a way that you can see on the next slide, which is if the initial or final leg of combined transport has a nature of bilateral operation, then we do not apply posting rules. If this initial or final leg of combined transport has a nature of cross-trade or cabotage, then yes, you do apply posting rules. Okay, so that's just to take into account, especially in cases of islands in EU. And that, of course, would foresee combined transport. So we have seen so far the basic rules, but there are two important exemptions that I would like to introduce you today. Okay, let me just check the time. I think I'm still have 2 minutes. I have to run then. Exemptions. Okay, so limited additional activities of loading and or unloading. So-called rules 1+1 or 0+2. Cross-strait operations carried out in the context of a bilateral operation could not be also covered by could be not covered by posting rules. Okay, so previously I showed you that cross-strait operations were always covered by posting rules. However, if these cross-strait in limited numbers, either 1+1, one during the outgoing and one during the incoming bilateral operation, could also be exempted from posting, but that could only be expressed on the map. So I understand the definition sounds quite difficult, but when you see that on the map, it should be clearer. Okay, there is also a reference to G2V2 tachograph as a condition, but of course nowadays all the operators would be in possession of a G2V2 tachograph. So it's just to confirm. Here you will find also, as you will also receive these slides afterwards, there is a definition about this exemption, but again, I will show you that on the map. And you can see that the operator from Poland has a G2V2 tachograph on board. He loads in Poland and unloads in France. Okay, this is a bilateral operation. But as you can see, he didn't go in a direct straight line to France. He actually crossed a few other member states. During this outgoing bilateral transport operation, he also performed one cross-strait between Czech Republic and Germany. Again, why cross-strait? Because he's not from Czech Republic, he's not from Germany, okay? The operator comes from Poland, okay? So he did an additional transport operation between two member states which are not his member state of establishment, and this is cross-strait. However, this cross-strait happened under the umbrella of a bilateral operation, okay? And this is the first cross-strait within the outgoing bilateral. Then he takes a load in France and delivers it back to Poland. So another bilateral returning operation, okay? Under that return operation, he also performs another cross-strait. And what is important here, this is an exemption, okay? And that means that practically the two cross-strait operations will not be covered by posting rules because they are done under an umbrella of bilateral operations. Okay, so the exemption, the allowance, let's say, for exemption is one cross-strait operation on the outgoing bilateral and one cross-strait operation coming back home. Okay, these two cross-strait operations will not be covered by posting. Let us see the second rule, which only applies to transport of goods, the so-called 0+2. And let us see the 0+2 then. This time is an Irish operator with a G2V2. Okay, he loads in Ireland, then goes directly to Sweden to unload in Sweden. So it's a bilateral operation, after which he goes to Poland, loads in Poland, and then delivers goods back home. So as you can see, two bilateral operations. First, he took goods from Ireland, which is the member state of establishment, to Sweden, a bilateral operation. During this bilateral operation, he did not perform any cross-straits. However, on the way back, he performed two cross-strait operations, okay, which are from Czech Republic to Germany and then from Belgium to France. Both of these returning cross-straits will not be covered by posting rules because they benefit from this operator would benefit from the 0+2 rule, which allows for the two cross-strait operations not to be covered by posting. Okay, I hope that was clear when it comes to the exemptions. And here we have one slide concerning EU-UK Trade and Cooperation Agreement, which will show the operation performed by a German operator who loads in the Netherlands, okay, and delivers to UK, and then drives unladen to another location in UK, picks up a load and then delivers to Ireland. Okay, so again, this is a German operator performing two operations between member states and UK, none of which is his member state of establishment. Okay, so for the member states, according to EU law, this is a cross-strait operation. But the TCA agreement does not see that as a cross-strait operation. So what will happen with posting? There will be an obligation to, let's say, to post the driver. In other terms, posting rules will apply in Netherlands to this German operator, to the driver who's performing the operation on behalf of this operator. Okay, and the posting rules to Netherlands will be triggered. Okay, so he will be posted to Netherlands. However, once reaching UK, he will not be posted in UK because UK will see that as a bilateral operation. So what happens? He is then, when delivering, being a German operator, delivering between UK and Ireland, he will then be reposted to Ireland once he actually crosses the border. Okay, so that's important to see how these rules are actually applied in practice. All right, but because the time is running, I will just quickly show you, and of course the end of obligation to post worker is at the unloading. Quickly, the enforcement practices. So what is requested from a posted driver at the roadside? At the roadside, he's requested to have 3 types of documents, okay? These 3 types of documents are tachograph records, consignment notes or other document proving the transport operation, and the posting declaration. Okay, so it's important to know that the tachograph records could be requested both from the vehicle unit and the driver card. Okay. Then we have consignment notes, and here, of course, we are speaking about freight transport, because in passenger transports there are other types of documents according to the legislation, but in freight transport we are speaking about either ECMRs or paper form of the consignment notes or other documentation proving transport operation. But the most popular are, of course, consignment notes, CMRs, and then posting declaration. So how do we generate this posting declaration, which is necessary in case the driver is posted? We generate it through the Road Transport Posting Declaration portal, which you see, that should be my last slide, on the Road Transport Posting Declaration portal. Okay, you see also the address of this portal on the screen, which is postingdeclaration.eu. Here, every transport operator who will perform operations which are covered by posting rules has to first create a profile, okay? And through this profile, then he will also create profiles of the drivers that will be posted and then submit the declarations to the member states to which he intends to post the drivers, so where the operations covered by posting would actually happen. And more details about that we will present at the next sessions, which will be happening at the end of June. So stay tuned with under our campaign. Ivan will tell you, Antonio, more about them. And I give the floor back to Ivan. Thank you very much from my side.
No, actually, thank you, Ivona, and thank you for that clear and insightful overview. I would say I believe that you have certainly helped clarify the key points for our audience on what is an important topic. And now it's time to reach out to John Norton from the Road Transport Authority in Ireland, who will present us with an overview of actions LCV operators should take in preparation for roadside check. So dear John, if you are ready, please, the floor is yours.
Yeah, good afternoon, everyone. I'm just going to take you through from the Irish perspective. We carry out roadside checks to ensure that HGVs and LCVs will be compliant with all the rules that they have to comply with. It'll be largely similar experience, or should be, in other member states, but there will be some differences as to who carries it out, whether it's an inspectorate or whether it's a police officer or both in some cases. So we'll just take you through the Irish experience, or what it should be like. So for operators, what they do to prepare They need to ensure that their van or their LCV is fitted with a smart tachograph, and it must be a Generation 2, version 2, or G2, V2 tachograph, and it must be calibrated. This has to be done every 2 years, but it must be calibrated when it's fitted to the van initially. They must ensure that their drivers also have a driver card, and that they must be trained in the use of the driver card and of the tachograph. If the journey, as we've seen from some of the previous speakers, is cross-trade or cabotage, apart from some limited activities of loading or unloading, then a posting declaration must be made prior to beginning the journey. And a company card, similar to a driver card, but to allow the company to download the tachograph, should be obtained from the member state that they're established in. And they must download the tachograph vehicle unit every 90 days and the driver card at least every 28 days. They should also ensure that those downloads are analysed, and if there's infringements found, that the drivers are informed about those infringements, and they must document that conversation that they've had with the driver. So, I'm a driver. I'm on an international journey in my van or LCV. What do I need to have with me, or what do I need to carry? Okay, so you'll need your driving license, your digital driver card. You'll need any manual records you've made, as we heard earlier about if you've got a malfunctioning tachograph, or you've had to make a manual record that you couldn't make using the tachograph. You must carry those with you for 56 days, and any printouts you've made for the previous 56 days, and you should be able to present them at a roadside check if you're asked for your records. You must have a community license if you're carrying goods for hire or reward, and that's in since the 21st of May 2022. It's just the tachograph element that's been introduced from the 1st of June. Okay, so the cabotage or cross trade. So you need a copy of the posting declaration submitted by your employer through the RTPD. So you'll either need a physical paper version, or you can have an electronic version on your phone or your laptop or whatever it may be. So if a driver is employed by an Irish operator, is from outside the EU or the EEA, they must also have a driver attestation on board. And you must also be able to show consignment notes or CMR documents or any other delivery dockets that can show what journeys you've done and what deliveries you've made as part of your activities. So what specifically happens in Ireland at a roadside check? Okay, so we've two different competencies really that the Road Safety Authority look after. One's carried out by a vehicle inspector who are truck mechanics, and they look at the roadworthiness of the vehicle. And at the same time, a transport officer will ask you about your documents, your driver's license, your driver card, driver attestation form, your printouts, and your tachograph information, basically. So the transport officer will carry out a download of current day and the previous 56 days from your driver card, and they will also always download the tachograph vehicle unit. They then take that away to an analysis normally done on a laptop to see what activities were done and whether they comply with all the rules and regulations and the limits. So if applicable, a posting declaration will be asked for, and that will be checked. The driver will also be asked about their activities recorded in the downloaded of the tachograph, and they'll be asked where the deliveries were made, etc., to just ensure that the information marries up with what is recorded in the tachograph. And outcomes then can depend on what is presented, how many infringements, whether there's patterns to the person's behaviour, and depending on the seriousness of what's discovered, anything from no infringement to a warning to right the way up to prosecution can be started from the roadside at that stage. It may also trigger a premises inspection that may happen at the operator's premises if it looks like there's something that needs to be further investigated, or that may involve a similar problem with other drivers that just needs to be looked into. So there's a lot of reference material, and a lot of this will be new, especially if you only operate LCVs. I would recommend you familiarise yourself with the following. So in relation to the smart tachograph on the Road Safety Authority RSA.ie website, there's a lot of Q&A specific to our market, but also to others in relation to the smart tachograph 2, the G2V2. The Workplace Relations Commission website also has all the information about posting drivers. Also on RSA, another part of our website, you can apply online for a driver card or for a company card to allow you to download your tachograph vehicle unit. And if you have an LCV that needs to have a tachograph fitted and doesn't have a tachograph, or it has an old tachograph and needs to be retrofitted with a G2V2, the NSAI website, that link there will tell you where the workshops are local to you. And if you wish to apply for a road transport operator's license, that's the link there to the RTAL website. Just a few more, but this is all relevant information and it's all accurate information, so it's important that you do actually go in and read some of this. The tachograph in general, there's very, very good information on the European Commission website there. And also in relation to the mobility package, which were the main changes really over the last 5 or 6 years in relation to driver's hours and tachograph and transport, basically. And then there's an excellent presentation on the European Labour Authority's website in relation to LCVs, and it just breaks it down into very simple terms as to what the main rules are that apply to you, but the more in-depth stuff is available on those other links. Okay, and that's it. Back to Ivan. Thank you.
No, thank you actually, John. And now we move right away to Fidelma Hardiman from the Workplace Relations Commission for her presentation on ensuring compliance. Dear Fidelma, if you're ready, the floor is yours.
Good morning, everyone. I'm Fidelma Hardiman, so I'm a regional manager within the Workplace Relations Commission. So my role here today is just to give you some basic information in relation to the WRC and what you can actually expect if we are at a roadside stop with our colleagues from the Road Safety Authority. So I suppose just to start with, for those of you that aren't familiar with the WRC, our role is there on screen. It's basically to ensure compliance with employment legislation. We are impartial in all of our inspections. We ensure the legislation is being complied with, and therefore both employers and employees are protected at all times. So we have a regionalised structure. We have 5 offices, one in Dublin, Ennis, Carlow, Cork and Sligo. So we have inspectors based in all of those regions and carrying out inspections in the respective counties within those regions. Night work is a key element of our inspection strategy. So our inspectors would be out at night operating in terms of inspections in towns, businesses that are open after regular office hours. And we're also authorised officers under the Employment Permit Acts, which means that we monitor compliance with employment permits when the department issues them to employers. So just generally, inspectors' powers, it's important to know for yourselves what we're allowed to do and the reason why we ask for certain things. So in accordance with the Workplace Relations Act, inspectors have the power to enter a premises or place of work at all reasonable times where we believe that there is an employer or an employee relationship. So what we deem as a reasonable time is basically when the business is open and operating. It means that we can enter and we can look to carry out an inspection. So at the premises, we can inspect and take away copies of records, books, documents, whichever we deem there to be an employment record. We can remove them, we can inspect them. Importantly as well, we can require any person at the place of work to give us information which we deem necessary in order to carry out our functions under the Act. And that can be the employer or the employee. So we can require either or to give us the information that we require. And we can examine the records there on site as well. It's an offence to obstruct an inspector in the course of exercising their powers. So it's important that if you come across an inspector or we're aiming to carry out an inspection, that you actually cooperate with us, because it is an offence prosecutable in the district court to obstruct us in the course of our duties. So joint investigation units, and I suppose this is where it becomes important and relevant for our work with the Road Safety Authority. All WRC inspectors are what we call JIU officers, and what they are is inspections that are carried out with colleagues from, it can be the Revenue Commissioners, so Department of Social Protection, An Garda Síochána, the Road Safety Authority, the Private Security Authority, and the Marine Survey Office. So it can be with one or all or multiple of those combinations can carry out inspections at any time together. I suppose the purpose of doing it is it's an effective way to carry out an inspection of an employer without, I suppose the employer might think it's minimal disruption, but we would see it as minimal disruption because it's one visit where all inspectors can look at the records that they need at one time without having to come in on multiple days. So just to focus then on our cooperation with the RSA, we do carry out roadside stops with the RSA. And what your drivers would be asked at those roadside stops, and it's important to know the questions that we ask so that they have the information available. Obviously, the name of the employer, the location of the employer, their own details, so their name, their date of birth and their nationality, information in relation to postings if applicable, and general employment rights information. So we would be asking the drivers, for example, do they get a pay slip? How much are they paid? Do they have a contract of terms and conditions of employment? In relation to nationality, depending on where the driver is from, if they're outside the European Economic Area, we would also look for proof that the driver has an entitlement to work within the state. So that could be an employment permit issued by the Department of Enterprise, Tourism and Employment, or some other relevant form of documentation. So depending on the outcome of that interview, a follow-up inspection could take place at the employer's place of work, where we would look for more detailed records. We also carry out inspections on site at employer sites with the RSA as well. I suppose just to give you an idea then, if a full inspection was carried out, the records that we would be looking at, we'd be looking for the employer's registered number with the Revenue Commissioners. We'd be looking for a full list of employees with all details, including their names, address, their PPSNs, their job classification, when they started, when they finished if relevant. It's important to note that we can look for records for over a period of 3 years. So if we deemed it necessary, we could look for all of that information. We would look for written terms and conditions of employment for each employee, a record of their holidays, their public holiday entitlements, records of hours of work. Now, this can include, in respect of your industry, a copy of the tachograph in a readable format or a timesheet. Payroll details, gross to nets to show the rate per hour, any overtime, deductions for board and lodgings provided, commission, bonuses. So we would be looking at copies of pay slips to ensure that all of these are in line with the legislation. I suppose if you have any under 18-year-olds working, we would look for a register. That would be more relevant, I suppose, to workers that are maybe working at your actual site and not out on the road. And then employment permits are evidence that a permit is not required as appropriate for non-EEA nationals. I suppose enforcement, and I should stress, we operate on a compliance model, so we will always work with the employer in the first instance to ensure that compliance is achieved, because that benefits both the employer and the employee. But if in the event that we have to go down the enforcement route, it can take a number of different methods. We can issue a compliance notice, a fixed payment notice, or a prosecution in the district court, which then the inspector will be involved in putting together submissions, preparing summonses and books of evidence. The inspector would attend the court hearing and act as a witness on behalf of the minister or the WRC, and then they may attend the Labour Court for hearings on appeal. So that's the end of my presentation. It was just a short whistle-stop tour of what we do and how we can link up with the RSA, so that there's no shock or you're not prepared if we do come across you at a roadside stop. So with that, I'll say thanks and hand back over to Ivan.
Thank you. Thank you for this presentation, Fidelma. So we are at the end of today's information session, but we still have a few key points to cover. Just as we did earlier, we are now going to address some of the most relevant questions you submitted in advance, but we will also take some time some of the questions that you have placed in Slido during this live session. I will read each question aloud and then invite our experts to help us with providing an answer. So let me first start with the first question, and I would kindly ask Ivona to help us with answering this one. So Ivona, if you are ready, I will read the first question, and the question reads, is it mandatory to register a trip in the IMI portal before every single international LCV journey?
Thank you, Ivan. It's actually a very good question. As nowadays, in fact, I did not present much about the portal itself, but about the posting declarations. However, you will find still the videos that we prepared in 2021 and 2022 for the operators in the heavy vehicles, which were covered by these, posting obligations already in 2022 from February. Where you can actually find more details. These videos are on LA YouTube channel, and you can actually still most of the information provided in these videos is valid, because of course in the meantime this posting declaration portal changed a bit. It was upgraded. However, most of these videos are still remain up to date. So what is mandatory is, of course, to have a posting declaration. However, let's say there was a decision taken at the legislative process, let's say, and then of course the all portal was set up in a way to allow for submitting a declaration for a period of up to 6 months. Okay, so that means that an operator can actually submit a declaration to a member state where he intends to perform operations covered by posting. So let's say his business model is foreseeing, let's say, cabotage operation and cross-trades operation in another particular member state. He knows that he continuously does that throughout, months, let's say in the weeks. Then the possibility to submit a declaration for 6 months is, of course, to accommodate the need of the business, not to, overburden companies in order to submit every single information about every single operation separately. Okay, but at the same time, it is important to remember that according to the legislation, it is requested to keep these declarations up to date. So we would make a call to the operators not to submit declarations, to all of the member states for all of the 6 months if they really do not intend to perform operations in all of these member states in the, let's say, next 6 months. Because, of course, it is possible to submit a declaration for an envisaged posting. Of course, the situation may change, but then it is requested to, to update them, keeping them up to date. So if you do not intend to go somewhere, it is better not to submit a declaration there, as that just overburdens the system. Thank you.
No, actually, thank you for this detailed answer. And let me switch to another one. And this is also regarding the posting, so I will kindly ask you to stay with us. So does the posting of drivers rule apply to every international trip or only to cabotage and cross-trade?
Okay, so that's a question if someone just, let's say, connected to our meeting now in this moment. So this question, of course, finds an answer in the slides that I presented. So yes, there are certain types of operations that are covered by posting rules, and cabotage and cross trades are in general covered by posting rules. Cabotage always, okay, but in case of cross trades, there are exemptions that might apply in the moment that a cross trade operation is performed under a bilateral operation, which bilateral by default is not covered by posting. So I invite you again, if this is still unclear, to rewatch the presentation and get acquainted with the rules, which are then also quite well explained in the scenarios provided by the European Commission.
Perfect. And we still had another question regarding the posting, and it also concerns the topic that you already covered during the presentation, but nevertheless, it's always good to repeat on the important aspects. So the question is, what documents must I carry in the van to prove compliance with posting rules during a roadside check?
Yes, so of course posting is not, will not be like a isolated element of the roadside check. However, only for posting, according to the Directive for Posting of Drivers, like Specialis, you should have 3 types of documents. Yes, so there is a posting declaration, tachograph records, and the consignment notes in the transport of goods. However, of course, as you also heard from the presentation of our RSA colleague here, you will be asked for more documents because, of course, the roadside check normally also foresees the check of other pieces of legislation. So yes, again, only in terms with posting rules, we talk about 3 documents, and they are listed in the posting directive. So again, posting declaration, tachograph records, consignment notes.
Perfect. And the last one regarding the posting is the simple question. Again, the type of transport operation that is considered to be posting, and the question reads: are bilateral transport operations exempt from posting rules?
Yes, bilateral operations are not covered by posting rules. That means that if you as an operator only perform these types of operations, you do not even have to create a profile at the RTPD portal. You don't have to submit declarations for these kind of operations, okay? So depending on whether you exclusively do bilateral transport, which means that you are either delivering goods from the member state of establishment of the operator or to the member state of establishment of the operator, and then posting rules do not apply. So all the administrative requirements that are connected with it do not apply.
Once again, thank you, Ivona. Thank you for clarifying on that one. And now I would like to give the floor or invite Luca Tassoni from the European Commission to help us with answering a couple of following questions. So Luca, if you are ready, I would read the first question. So the first question is this applicable to all LCV drivers or just those involved in international carriage? And are there any exemption or special rules for specific professions such as butchers, caterers, or other food-related trades and small companies?
Thank you. Yes, the obligation is applicable, as we said, in international transport or in the cabotage operations. Of course, we saw also the definition of international carriage, which is provided by Regulation 1072. And yes, again, if the transport is limited, confined to the national borders, to the national territory, there is not the obligation of fitting the LCVs with the tachograph. And if there are special exemptions, we saw that the point HA that was added with the mobility package together with the new provision, there is also an exemption which is provided for the own account, and also another condition that should be met is that driving does not constitute the main activity. So for all the type of transports, if all the conditions for the definition of own account are met, and also the condition related to the driving not constituting the main activity, so this is a situation that fall within the exception provided in Article 3.
Perfect. Thank you, Luca, for this one. We still have additional question, and this is a rather short one. So will LCV speed also be limited to 100 kilometers per hour?
The speed limitation is not related, the device, the speed limiter is not related to the tachograph. It is related rather to the classification, to the international category of the vehicle, and it is applicable only for the vehicles which are engaged in the transport of goods over 3.5 tons, and the vehicles engaged in the transport of passengers over 9 seats. So the vehicles in the categories M2, M3, and N2 and N3. And the LCVs are classified in the category N1. So for the LCVs does not apply the speed limitation, and also the device, the speed limiter.
Thank you. And the next question on the list is, will there be any grace period where control authorities will not penalize drivers still learning the new system?
For the moment, no grace period is envisaged, and so the new provisions should apply starting from the 1st of July 2026.
Thank you. This one was pretty straightforward, I would say. And the second question is, in the case of a bilateral transport operation, so in this case, Romania and Hungary, operated by a Romanian LCV driver, when should the tachograph registration be started?
As already also Seamus replied to a similar questions, the obligation starts from the starting of the operation itself. So from the point of departure, the border is not relevant in this situation because the international operation starts as soon as the vehicle leaves the point of departure in the country of registration.
Thank you. And we have yet another question which is more related to the geographic aspects, let's put it like that, of the trip. So can you please confirm that these new rules do not apply to vehicles if they do not travel from Republic of Ireland to the north of Ireland or the UK and EU?
Yes, this is also similar to the previous question on the domestic or international transport. If in this case the vehicle, the transport is limited, is performed by a vehicle registered in the Republic of Ireland and is limited in the territory of the Republic of Ireland. So in this case, this is a domestic national transport which does not fall within the international transport, so it is not subject to the obligation of the tachograph.
Thank you. And I have just one more question for you, Luca. So in the event of a roadside check after the 1st of July, how should an LCV driver document the last 56 days concerning that there are still no tachograph records available?
I would say, if I understood the question, that in this case, from the 1st of July, all the obligations related to the tachograph start for the LCVs. So also the obligation of the 56, the obligation of the 66 days. So we cannot ask that a vehicle is able to provide evidence or to record the days that are before the 1st of July. So I would say that the count of the 56 days start from the 1st of July itself. So for example, the 11th of July, it will be mandatory to record only the 11 days, the past 11 days, not of course the days that were before the starting of the obligation.
Thank you. Thank you, Luca, for providing the clarification on this as well. And I would also like to once again thank all the speakers who participated in the Q&A slot. So thank you, Seamus, thank you, Bona, and thank you, Luca, once again. We will now move to yet another interesting topic, focusing on the practical tools available to you. I am pleased to welcome my ELA colleague, Tonio Bur, from the Information and EURES unit. And Tonio will present ELA's activities in the area of road transport. So Tonio, if you're ready, the screen is yours.
Thank you, Ivan. As you have heard in the beginning, this session was organized by the so-called European Labour Authority, or short ELA, and it's my pleasure now to give you a short overview of what the ELA is and why we are relevant for drivers, operators, and social partners engaged in international road transport. There are a couple of very useful information resources which I will present and which can support you in learning more about the new rules for light commercial vehicles. As was mentioned several times already, we will make available all the presentations, including this one, so you can read up later and use all the links which we provide. I want to catch your attention now with a bit of a provocative statement, which underlines how important events like this one are. The statement you can see here is something that might concern you when you're conducting certain international transports, namely posting. And this statement is something that we hear a lot from workers and employers who are engaged in posting. And here you see now a possible solution for this challenge, and that's very easy. It's the availability of accurate, up-to-date, and easily understandable information. So do not worry, we're here to help, and I will now show you how we can support you. Very quickly, I just want to tell you a little bit about the European Labour Authority, or ELA. It's one of the newest EU agencies, a so-called supervisory and implementing authority, and it's located in Bratislava in Slovakia and was only founded in 2019 with the main goal of facilitating labour mobility, like, for example, the possibility for operators of light commercial vehicles and drivers to offer their services EU-wide. So in a nutshell, we make sure that the European rules on labor mobility are applied, what we say, in a fair, simple, and effective way to help strengthen fairness and trust in our most precious good, the EU internal market. We do this through 3 pillars that you can see here on the slide. So we have the information pillar. This is where I work with the main goal of facilitating access to information. We have the cooperation pillar. It supports cooperation and information exchange between member states and various stakeholders. And we have the enforcement pillar, which enhances cross-border enforcement of labor mobility regulation by, for example, coordinating cross-border inspections and enforcement actions. Now, let's look in more detail at what we do for drivers, operators, and social partners in international road transport. We organize road transport local information events, roadshows, and online information sessions like the one today. They can be on-site or online in different EU member states, and they target drivers, operators, and social partners and cover different aspects of labor mobility in road transport. There are also very practice-oriented resources which can help you understand the rules of Mobility Package 1. They have been prepared as a part of our former campaign that you can see on the slide here. It's called Road to Fair Transport, and the campaign includes flyers about, for example, driving and rest time rules, but also about posting. And they are available in all EU languages and even a couple of relevant non-EU languages. And it can be downloaded free of charge on ELA's website. So if you click on the pictures on this slide, you will automatically be directed to the respective resource. Keep in mind, it's free of charge and available in many different languages. We have videos, leaflets, infographics, posters, and other knowledge resources. You can also see on this slide that we are developing and implementing other helpful tools targeted at supporting operators, drivers, and social partners in the international road transport sector. Currently, for example, we are working on a so-called remuneration tool aimed at creating transparency about the applicable remuneration for posted drivers in international freight transport. We will inform all relevant stakeholders once this important tool is ready for use. I would also like to inform you about the campaign that my colleagues have already spoken about. It concerns the new rules which apply to you as of 1st of July 2026. The campaign is called Light Vehicles Big Changes, and it targets drivers and operators of light commercial vehicles. Through the campaign, we inform about mandatory rules concerning driving and rest time rules, the use of the smart tachograph version 2, and the rules connected to the posting of drivers. So if you click on the link which is on this slide, it will lead you to our campaign website. There's a lot of useful information on the rules and its application. There's a downloadable flyer which sums up the most relevant points for you, and more material will follow in the course of the year. For now, the material is in English, but we're in the process of adding other EU and third country languages. We will also organize more webinars like these. Another one is scheduled for 30 June this year, one day before the application of the new rules. And you will find more information on these in due time in the events section of ELA's website. And I have included the link on the bottom of this slide. The European Commission, and my colleague has already spoken about it a little bit, also makes available useful information about road transport. If you click on the link on this slide, it will lead you to the webpage on EU rules for working in road transport. There's a lot of details about all relevant aspects of the rules. And you can see on the left-hand side the different topics ranging from driving and rest times, use of tachograph, posting, and information on the minimum wage which applies to posted workers. This is a very important issue that has been mentioned before. It's the minimum or a collective agreement wage which applies to posted drivers. Again, this website is available in different languages, and I have included the link at the bottom of the slide. The next information resource is ELA's website. We have a special section on the social aspects of international road transport, and the slide shows you how to navigate to the relevant topics. We make available information on the legal background of the provisions in force in the road transport sector, but the website will also guide you to the campaign materials of Road to Fair Transport, the campaign I have mentioned earlier. All the material is available in several languages and free of charge. This is the official information website of the European Commission on Mobility Package 1. You can find definitions, explanations, and specifications on the applicable European rules in international road transport. There's also a very comprehensive FAQ section with answers to some very relevant questions, which many of you might have already asked yourself when on the road or when planning a route now. And here on this slide, you can see the entry point to the so-called Road Transport Posting Declaration portal. Again, it was mentioned by Ivona earlier. So I think this is some of the most important resources which we have put together on those slides. I'd like to share another important topic with you, and this concerns international skilled drivers in international road transport. ELA is host to EURES. It's the European Employment Services. It's a cooperation network designed to facilitate the free movement of workers within the EU member states, including Switzerland, Iceland, Liechtenstein, and Norway. And it helps people find jobs, and it can help employers or operators find drivers across Europe. As an employer, you can search for candidates according to your preset needs, and as an employee, you can upload your CV and create a profile so that potential employers can find and hire you. The prerequisite is a so-called EU login. It's also free of charge, and it gives you access to many useful EU services. You can find the link again on this slide. Finally, I would like to acquaint you with Solvit. It's a free service provided by the EU to help citizens, but also businesses, to resolve problems they encounter with public authorities in another EU country. Solvit can help if you're facing unfair rules or decisions from public authorities in another EU country, or if your EU rights are being breached and you haven't taken the case to court yet. You can submit your problem online through the Solvit website or reach to the Solvit center in your country. Solvit gives legal background information and, if need be, reminds authorities of your EU rights and works with them to fix the issue. This is it. I hope the information I've shared with you today is useful for you, and that it will also help you navigate through the new rules which will apply to LCVs as of 1st of July 2026. Thank you for your attention, and I'm handing back to Ivan.
Thank you, Tonio. Thank you for highlighting those valuable information sources. We for sure encourage our viewers to consult these sources to stay updated on the relevant rules. We are reaching the end of today's session, but we still have one final point on the agenda, and those are our closing remarks. I would now like to pass the floor to Justin Martin and Monica to offer their final thoughts. So, Justin, I will start with you. The floor is yours for your closing remarks, please.
Thank you, Ivan. So just briefly, I'd really like to thank our colleagues today for their very insightful presentations. I really need to emphasize that the changes are significant that have been spoken about today, and putting systems in place to ensure compliance should be prioritized. And this is especially true for operators who do not have mixed fleets, and therefore they're not already familiar with the rules applicable to heavy goods vehicles that they would have in their fleet. So I appreciate this is onerous, but these rules are designed to ensure minimum road safety standards and working conditions for drivers are met. But please don't panic. There is still time, and there's lots of help, as our previous speaker has outlined. There's lots of help available. For those of you based in Ireland, please visit our website and the Road Safety Authority, www.rsa.ie, where we have compiled comprehensive information on the Irish implementation of this and a list of FAQs. You can also use that website, our webpage, to link to the relevant ELA guidance that's been spoken about. So with that, I hope you enjoyed, and more importantly, I hope you took something very useful from today's event. The message for me is very simple. If you own or operate vehicles in scope of these new rules applying from the 1st of July 2026, you need to start planning and getting your training and your retrofit activity planned immediately. So I'll hand you over to Monica now for some very final remarks. Thank you.
Thanks, Justin. So before we wrap up, I'm going to add to Justin's message. Just thank everyone who helped in making of this event. So my sincere thanks to the authorities in Ireland, the Road Safety Authority, the Department of Transport, and the Workplace Relations Commission for their cooperation and their continuous engagement in this awareness raising campaign. And I would also like to thank all my ELA colleagues, the ones who participated in this event, but also the ones behind the scenes, making sure that the event goes well. And very importantly, thank you to the audience for engaging. Our apologies as well for the technical issues on the way, but hopefully you were able to follow the presentations and the speakers and all the notes. But thank you for all the questions that were submitted, and thank you for being active in that sense. And please submit more questions, because we are planning another event, a wrap-up event on 30th of June. So these questions really help us to shape these events and to tailor the agendas that they really help the operators, drivers, and the authorities to prepare for the changes ahead. In the meantime, please follow the ELA social media for any updates on this topic and all the information on future sessions and materials. So thank you once again for your time and all valuable contributions today. Thank you.
Thank you. Thank you both to Justin and Monica. And before we officially sign off, just a quick reminder. Please note that today's presentations will be available on the ELA website starting from tomorrow, so that is the 29th of April. And let me once again repeat that you can find the direct link in the description of this video. Additionally, a recording with interpretation in all EU official languages will be uploaded to the ELA YouTube channel in the coming weeks. So if you'd like to watch the recording of this session in your language, please follow our YouTube channel for future uploads. Also, as Monica mentioned, since we received a number of questions from you during today's live session, please know that since we did had dedicated time on disposal to address those questions, for sure we will take them into account for shaping the future content of our upcoming online session dedicated to this topic as well, which will be taking place later in June. So please follow on ELA YouTube social medias for more information about that. Finally, a big thank you to all our speakers, especially the European Commission, Road Safety Authority, Department of Transport, and the Workplace Relations Commission of Ireland, as well as to all of my colleagues from ELA. Most importantly, thank you to all of you for joining us and for your interest in this topic. We hope to see you at future ELA events and have a lovely rest of the week. Goodbye.